Hello and welcome back to our presentation on self-building, building your own home with Woodberry Homes Ltd. This series is broken into 4 parts. This is part 3, arranging acquisition of a selected plot. Arranging acquisition is one of the more difficult parts of the process. Unless choosing from an array of land parcels made readily available for self-builders, you will be faced with the challenge of finding out who owns the land that you want to purchase, how to approach them, and negotiating a purchase agreement. We will look at dedicated self-building sites, finding an owner, planning permission, and negotiating a purchase agreement. By dedicated self-build sites, we mean plots of land that have been listed for sale, specifically for use in a self-build project. There are many websites that list land which may be suitable for self-building. For obvious reasons, we aren't going to list them here, but if you're curious, they are just a search engine away. Just because someone has listed a parcel for self-builders does not mean it is suitable for a self-build project. View it as though it were just any other parcel of land that is up for sale for any purpose, because ultimately that is what it is. The seller just wants to sell it. Tagging self-build on the advertisement doesn't change the land, it just attracts a particular audience. Approach the property as you would when looking to purchase a car. Consider what might be wrong with it. Why does the seller want to sell it? Why did they acquire it and not do anything with it? It might have been purchased to be sold on at a greater price to raise capital, or have been a section of land that was unused in a previous development project. However, it might also be land which was purchased without sufficient care, and the purchaser now realizes that planning permission might be too expensive or impossible to get on it, and are now looking to pass on their misfortune to someone else, just like a private seller might try to get rid of their vehicle before its MOT is due for renewal, in order to recover as much as they can while avoiding paying for several expensive repairs. As said before, approach it like any other parcel of land. Don't rush to buy it just because it was listed as being for a self-builder. It might be the worst decision you make in your venture, and put a stop to it before you even get started. Consider consulting with a professional, such as Woodberry Homes, who can assess the land for you, lending you their expertise, sparing you a potential unfortunate purchase, and possibly significant otherwise unnecessary expenses later on. Let us make your land acquisition as stress-free as possible, carrying out the legwork and reducing the risk to you, your finances, and your project. Finding the owner of a parcel of land you're interested in can be challenging. The land may be registered since registration became mandatory. However, registration is only required upon certain triggering events, such as a sale or division, and finding the owner of unregistered land is much more difficult than if the land is registered. The land likely won't have an address, since you're looking to build something on it, meaning something hasn't already been built there. But registered land will have a reference number, recognizable by Her Majesty's Land Registry. This reference number is called the title number, and can only be obtained by using tools provided by or through the Land Registry. There will be a service charge to obtain copies of this record. These documents are not only important to identify the owner of the land and their contact information, which will appear under the title register. There is also a title plan, which will show the rough boundary of the land, indicating how much of the possibly vast area is under the same title. The title plan may reveal that the land parcel is quite small, perhaps even too small, on the edge of a much larger parcel, or it could be that the entire area is one parcel, under the same title number. This obviously affects whether you will proceed, and how you will proceed with your negotiations and subsequent purchase agreement. There is also something called the charges register, which may list interests in the land held by other parties in equity, as well as easements and covenants. However, it's important to know that an interest, easement or covenant does not need to be registered on the charges register. Registering it simply creates a record, evidence to support a potential claim. This is important to understand, because just because something isn't registered on the charges register does not mean it's not an actual encumbrance on the land. This is why inquiries must be made before purchasing any property. As mentioned, there are tools available which will make identifying parcels of land, including their sizes and title numbers, relatively simple. However, they are premium services and can be quite expensive for an individual who won't necessarily need to commit to looking up a significant quantity of title numbers. As with most services, the more you need, the cheaper each unit becomes, so using a professional like Woodberry Homes to identify the title numbers for prospective areas is recommended. Not only will you benefit from the professional expertise, but it'll likely save you money. The need for planning permission to be able to build on the land is why it is so important to carry out checks and assessments prior to a purchase. If you can't get planning permission, the land is worthless to you in your self-build project. Further, it will be discoverable by potential buyers that an application for planning permission failed, likely making it less desirable and making the value of the land on the market lower, resulting in a loss of capital. Assuming risk assessment has been carried out and you've got the land with confidence in your success of getting planning permission, you need to, if not done so already, create a document outlining your intentions for the land. This is the outline application, which needs to convince the planning authority that you are a serious developer whose intentions are in accordance with the various regulations that govern residential construction, and that you have made necessary considerations and taken necessary steps to mark you as an individual whose application would not be a waste of their time to review. If the outline application is successful, you may then proceed to make the actual planning application, which will require more detail, including architectural plans, details of materials, and how any potential issues will be handled. Anything and everything to convince the authority to grant permission. The application is expensive and cost is based on the size of the proposed development site. You quite literally need to argue your case with every persuasive arguing technique you have and every reason you can find why the authority should approve your application. This process can take anywhere between 2 and 6 months, sometimes longer if there are appeals. There is an alternative, more recent route, called permission in principle. The process is similar, but also cheaper and faster. The extra speed and affordability is in balance to the fact that the permission in principle gives less permissions than planning permission, so you need to be sure that permission in principle is right for you, and right for what you intend to do before you apply for it. Otherwise you might find that you have to apply for traditional planning permission anyway, which means getting billed twice. Surveyors are mentioned in this list because, depending on the size of the land you acquired and the size of the development site within it, you may need to provide what is effectively a title plan, outlining the area you own, and the area in which you wish to build. If you wish to build on the entirety, and you already have a title plan produced for you when you purchased the plot, or you're using the one that existed for the land in the land registry, you may not need a surveyor, but it's something to consider. Negotiating a purchase agreement. Clearly, the possibility of not receiving planning permission is the biggest risk to a self-build project, and indeed any construction project, unless of course you buy the land that already has planning permission. This is possible because planning permission runs with the land, not with the applicant. This is important to realize and remember. Obviously, the major downside to buying land with planning permission already granted is cost. Land with planning permission is much more expensive. Applying for planning permission before buying the land makes sense, but what then stops landowners from turning around, thanking you for the planning permission and their land substantially increase in value, then looking to build on it themselves, or sell it with planning permission for a much higher price to anyone willing to pay? The answer is contracts, specifically conditional and options agreements. Conditional and options agreements are two types of contractual agreements. A contract is, of course, an agreement between two or more parties where something of value is promised or given as the cost to buy another's promise. In UK law, this value is called consideration. Contracts are not law, but they are enforceable at law. This makes their construction incredibly important. So while yes, you can enter a contract by scribbling something on a napkin like in the movies, and yes, there have been cases in real life where this has happened, it is highly recommended to use someone with experience in contract drafting as well as negotiations. A contract with a conditional agreement is exactly what it sounds like. The parties enter an agreement where at least some of the obligations laid out are only binding if and when specific conditions or a specific condition is met. In this case, the obligation would be for the seller to sell and the buyer to buy the specified land at the agreed upon price, and the condition would be on planning permission being granted by the relevant local authority. The contract essentially removes the risk of buying land and that won't be granted planning permission at the cost of some added complexity, legal fees, and a little time. An options agreement is essentially the same thing, except it gives the buyer the option to purchase rather than obligating them to purchase. This sort of agreement is a little more complicated and may require more conditions that favour the seller to balance the scales, not because the law demands it, but because a seller's negotiator should demand something more to make up for the possibility of the land being removed from the market or subject to a set of restrictions with the possibility that it would all be for nothing. An options agreement is more likely to be used when the contract concerns several parcels of land or a single parcel to be purchased in plots over a period of time. Getting a contract drafted is expensive, and to clarify, we are talking about agreements that come with a lengthy list of terms and conditions. You know, those things that you say you read when you tick that box. Conveyancing also has costs, especially if the original land parcel needs to be divided and surveyors involved. Using a professional like Woodberry Homes avoids the needs to hire a solicitor or a conveyancer to draft not just one contract but several, because after the first contract is drafted, negotiations start. It gets amended and subsequent drafts need to be produced. Professionals already have a number of contracts drawn up and variations or separate variations agreements ready to deal with anticipated communications from the other party. Since we're ready for them, we also save you time and are able to advise you in what particular counter-proposals mean, and what implications they might have. You should also choose the company that is going to represent you carefully. There are a lot of ways to convey a message, and the courts have seen many contracts with ambiguity and uncertainty of intention, forcing them to refuse to give it effect or impute the intentions, which means reason themselves what they think the intentions of the parties were, and by their power say that the law considers it so. By imputing these intentions, they give effect to the agreement which may not necessarily be the agreement that you agreed to. Perhaps the most famous ambiguity in contract drafting is what amounts to reasonable, or a reasonable period of time. Woodberry Homes, for example, clearly defines this term in our contracts, leaving no room for its interpretation. Remember, communicating intention in contracts is key. The clearer you are, and the clearer you can make it that the contract must have been understood to have a particular meaning, the better. For more information on what goes into a contract, you could look at the specimen of the standard commercial property conditions provided by the Law Society. Many contracts are based upon this, or rather incorporate these terms, but there are also many others available. If you have any questions at all, don't hesitate to contact us.